Question 1. Quality control measures reveal that an applicant for an Arizona Concealed Weapons Permit, CWP, has an arrest record from 3 years ago for aggravated assault. The applicant states that the charges were subsequently dismissed by the court due to insufficient evidence. The applicant is unsure whether to include this incident on their CWP application, as they were never convicted. What is the most appropriate course of action for the applicant regarding this incident on their Arizona CWP application? Option A. Fully disclose the arrest, the dismissal of charges, and provide a brief, factual explanation of the circumstances surrounding the incident. Option B. Provide a detailed narrative account of the incident, arguing why the arrest was unjust and the dismissal was appropriate. Option C. Omit any mention of the arrest and dismissal, as there was no conviction and therefore no legal disqualification. Option D. Disclose the arrest but do not mention that the charges were dismissed, as the arrest itself is the relevant fact. Correct answer is A. Fully disclose the arrest, the dismissal of charges, and provide a brief, factual explanation of the circumstances surrounding the incident. Explanation. This scenario is professionally challenging because it requires an applicant to navigate a situation where their past actions, though not resulting in a conviction, could be interpreted by licensing authorities as demonstrating a propensity for behavior that undermines the public trust necessary for carrying a concealed weapon. The applicant must accurately and truthfully represent their history to the Arizona Department of Public Safety, DPS, while also understanding how the DPS evaluates such information in the context of concealed weapon permit eligibility. The core of the challenge lies in the applicant's obligation to disclose all relevant information, even if they believe it does not legally disqualify them, and the DPS's duty to assess risk based on the totality of the circumstances. The best approach involves a complete and transparent disclosure of the incident, including the arrest and the subsequent dismissal of charges, along with a brief, factual explanation of the circumstances. This aligns with Arizona Revised Statutes, ARS, Section 13-3112, which governs concealed weapon permits, while a dismissal of charges typically means no conviction, ARS, Section 13-3112, E1, allows the DPS to deny a permit if the applicant has been convicted of a misdemeanor involving the unlawful use of a deadly weapon or dangerous instrument within the past 5 years. More broadly, the DPS has discretion to deny a permit if an applicant is a danger to themselves or others, or if there is any other reasonable cause. Full disclosure allows the DPS to conduct a thorough review, considering the arrest and dismissal within the broader context of the applicant's overall suitability, rather than potentially discovering the undisclosed information later, which could lead to denial or revocation based on a failure to be truthful on the application. This proactive transparency demonstrates good faith and respect for the regulatory process. An incorrect approach would be to omit any mention of the arrest and dismissal, believing that since there was no conviction, it is not relevant. This failure to disclose is a direct violation of the application's requirement for truthful and complete information. The Arizona Concealed Weapons Permit application requires applicants to disclose arrests, not just convictions. Concealing this information can be grounds for denial or revocation of a permit, even if the underlying incident would not have led to disqualification. Another incorrect approach is to only disclose the arrest, but not the fact that the charges were dismissed. While this is more transparent than complete omission, it can create a misleading impression. The absence of the dismissal information might lead the DPS to assume the case is ongoing, or that the applicant was found culpable in some way, necessitating further investigation that could have been avoided with full disclosure. This incomplete disclosure can still be viewed as a lack of candor. Finally, an incorrect approach would be to provide a lengthy, emotional, or argumentative explanation of the incident on the application. While honesty is crucial, the application is not the forum for a defense. The goal is to provide factual information that allows the DPS to make an informed decision. An overly defensive or narrative explanation can be perceived as an attempt to manipulate the process or avoid responsibility, which is counterproductive to demonstrating suitability for a concealed weapons permit. Professionals should approach such situations by understanding that the application process is designed to assess suitability and public safety. This requires absolute honesty and completeness in all disclosures, even for events that did not result in a conviction. When in doubt about what to disclose, err on the side of transparency. If an incident is potentially relevant, disclose it factually and concisely, and be prepared to provide further, truthful information if requested by the licensing authority. The goal is to build trust with the regulatory body through open communication. Question 2. The monitoring system demonstrates that an Arizona Concealed Weapons Permit (CWP) holder is approaching a local polling station on Election Day. The individual is a registered voter and intends to cast their ballot. What is the most appropriate course of action for the CWP holder to ensure compliance with Arizona law? Option A. Carry the concealed weapon into the polling place, as they are a registered voter intending to vote. Option B. Carry the concealed weapon into the polling place but ensure it remains concealed and is not displayed. Option C. Carry the concealed weapon into the polling place and inform election officials that they are a permit holder. Option D. Refrain from carrying the concealed weapon into the polling place. The correct answer is D. Refrain from carrying the concealed weapon into the polling place. Explanation. Scenario analysis. This scenario is professionally challenging because it requires an individual to balance their right to carry a concealed weapon with the responsibility to comply with Arizona's specific legal requirements for permit holders. The challenge lies in interpreting and applying the nuances of Arizona revised statutes, ARS, concerning where a concealed weapon may be carried, especially in relation to sensitive locations like polling places. Misinterpreting these laws can lead to serious legal consequences, including criminal charges and the revocation of a concealed weapons permit, CWP. Careful judgment is required to ensure adherence to the law while exercising a protected right. Correct approach analysis. The best professional practice involves a thorough understanding and strict adherence to Arizona revised statutes, specifically ARS, Section 13-3102, which outlines prohibited places for carrying a concealed weapon. This statute clearly prohibits carrying a deadly weapon or dangerous instrument into a polling place on the day of an election. Therefore, the correct approach is to refrain from carrying a concealed weapon into a polling place, regardless of whether the individual is a registered voter or believes their presence is benign. This approach prioritizes legal compliance and avoids potential violations of state law. Incorrect approach is analysis. Carrying a concealed weapon into a polling place because the individual is a registered voter and intends to vote is legally incorrect. ARS, Section 13-3102, explicitly prohibits carrying a weapon into a polling place on an election day, irrespective of the individual's status as a voter or their intentions. This approach fails to recognize the specific statutory prohibition. Carrying a concealed weapon into a polling place but keeping it concealed and not displaying it is also legally incorrect. The statute prohibits the act of carrying the weapon into the prohibited location, not just displaying it. The intent to keep it hidden does not negate the violation of the statute. Carrying a concealed weapon into a polling place and informing election officials that they are a permit holder is legally incorrect. While transparency is generally good, informing officials does not grant permission to violate a statute. The prohibition is absolute for the location on election day, and informing officials does not create an exception. Professional reasoning. Professionals facing situations involving concealed carry rights and legal restrictions should adopt a proactive and informed approach. This involves regularly reviewing and understanding the specific statutes governing concealed carry in Arizona, particularly those related to prohibited locations and circumstances. When in doubt about the legality of carrying a firearm in a particular location or situation, the safest and most professional course of action is to err on the side of caution and refrain from carrying. Seeking clarification from legal counsel or relevant law enforcement agencies can also be a prudent step when faced with ambiguous situations. The primary responsibility of a permit holder is to ensure their actions are always in full compliance with the law. Question 3. The efficiency study reveals that the Arizona Concealed Weapons Permit application processing times are exceeding departmental benchmarks. To address this, a supervisor proposes implementing a new procedure that prioritizes applications based on the applicant's stated reason for needing the permit, expediting those with urgent personal safety concerns. What is the most appropriate course of action for the permit processing unit to ensure both efficiency and strict adherence to Arizona law? Option A. Reduce the scope of the background checks performed on applicants, focusing only on immediate disqualifiers to speed up the review process. Option B. Conduct a detailed review of the current application workflow to identify specific bottlenecks, followed by targeted training for staff on the precise eligibility criteria and background check procedures mandated by Arizona revised statutes, ensuring no compromise on due diligence. Option C. Rely primarily on the information provided by applicants in their applications, minimizing independent verification to accelerate processing times. Option D. Implement a policy to expedite all applications that claim an urgent need for personal protection, as this aligns with the spirit of the Concealed Weapons Permit Program. The correct answer is B. Conduct a detailed review of the current application workflow to identify specific bottlenecks, followed by targeted training for staff on the precise eligibility criteria and background check procedures mandated by Arizona revised statutes, ensuring no compromise on due diligence. Explanation: the efficiency study reveals a potential bottleneck in the Arizona Concealed Weapons Permit (CWP) application processing. This scenario is professionally challenging because it requires balancing the need for efficient processing with the absolute imperative of upholding public safety and adhering strictly to Arizona revised statutes. A.R.S. Regarding firearm permits, a rushed or compromised process could inadvertently allow individuals who are legally prohibited from possessing firearms to obtain a CWP, creating a significant public safety risk. Careful judgment is required to identify and implement improvements without sacrificing the integrity of the background check and eligibility determination process. The correct approach involves a thorough review of the existing workflow to identify specific points of delay, followed by targeted training for staff on the precise requirements of a R.S. Title 13, Chapter 31, specifically focusing on the eligibility criteria and the mandated background check procedures. This approach prioritizes understanding and adherence to the law, ensuring that any efficiency gains do not come at the expense of due diligence. By reinforcing knowledge of statutory requirements and best practices for application review, the department can streamline processes while maintaining the highest standards of public safety and legal compliance. This directly addresses the core mandate of the CWP program, to permit responsible citizens to carry concealed handguns while ensuring that those who pose a risk to themselves or others are not granted such privileges. An incorrect approach would be to implement a blanket policy of expediting all applications without a corresponding increase in oversight or a review of the underlying legal requirements. This is professionally unacceptable because it bypasses the critical due diligence mandated by ARS. Section 13-3112, which requires a comprehensive background check to determine eligibility. Such a shortcut could lead to the issuance of permits to individuals who are disqualified due to felony convictions, domestic violence restraining orders, or other disqualifying factors, thereby undermining public safety and violating the spirit and letter of Arizona law. Another incorrect approach would be to reduce the depth of the background checks performed on applicants to speed up processing. This is a direct violation of a R.S. Section 13-3112, which outlines the necessity of thorough background investigations. Failing to conduct complete checks, even in the name of efficiency, creates a significant risk of allowing prohibited individuals to obtain a CWP, directly contravening the purpose of the CWP program and Arizona's commitment to public safety. A third incorrect approach would be to rely solely on self-reported information from applicants without independent verification, even if it speeds up the process. While ARS Section 13-3112 requires applicants to provide certain information, the responsibility for verifying this information and ensuring its accuracy rests with the permitting authority. Ignoring this verification step, even for efficiency, is a failure to perform a legally mandated duty and could result in the issuance of permits to ineligible individuals. Professionals in this situation should employ a decision-making framework that prioritizes legal compliance and public safety above all else. This involves 1. Understanding the specific statutory requirements of a R.S. Title 13, Chapter 31, related to CWP issuance. 2. Identifying potential process improvements that do not compromise the integrity of background checks or eligibility determinations. 3. Seeking additional training or resources to enhance staff understanding of legal requirements and efficient, compliant processing. 4. Implementing changes incrementally, with robust oversight and regular reviews to ensure continued adherence to all legal mandates and safety protocols. Question 4. The monitoring system demonstrates a traffic stop initiated by an Arizona Department of Public Safety officer for a minor equipment violation. The driver, who legally possesses an Arizona Concealed Weapons Permit (CWP), has a handgun concealed on their person. The officer approaches the vehicle. What is the most appropriate and legally compliant action for the driver to take immediately upon the officer's approach? Option A. Only present the Arizona Concealed Weapons Permit when specifically asked for identification, without verbally acknowledging the firearm. Option B. Begin to explain their right to carry a concealed weapon and question the reason for the stop before disclosing the firearm. Option C. Immediately and clearly inform the officer of the presence of the concealed firearm and present their Arizona Concealed Weapons Permit. Option D. Remain silent and wait to see if the officer notices the firearm before taking any action. The correct answer is C. Immediately and clearly inform the officer of the presence of the concealed firearm and present their Arizona Concealed Weapons Permit. Explanation. Scenario analysis. This scenario is professionally challenging because it requires an individual to balance their right to self-defense with the legal obligations and responsibilities associated with carrying a concealed weapon in Arizona. The core challenge lies in interpreting and applying Arizona Revised Statutes (ARS) concerning concealed carry, particularly when encountering law enforcement. Misunderstanding or misapplying these statutes can lead to serious legal consequences, including arrest and prosecution, even if the individual believes they are acting within their rights. The presence of a firearm, even legally possessed, introduces a heightened level of scrutiny and requires a measured, informed response. Correct approach analysis. The best professional approach involves immediately and clearly informing the officer of the presence of the firearm and presenting the Arizona Concealed Weapons Permit (CWP). This aligns directly with ARS Section 13-3102(p), which mandates that a person carrying a concealed deadly weapon must, upon request of a peace officer, display proof of valid permit and identify themselves. This proactive disclosure demonstrates compliance with the law, reduces potential misunderstandings, and de-escalates the situation by providing the officer with necessary information upfront. It respects the officer's duty to ensure public safety and acknowledges the legal framework governing concealed carry. Incorrect approaches analysis. One incorrect approach is to remain silent and hope the officer does not notice the firearm. This fails to comply with ARS Section 13-3102(p), which explicitly requires disclosure upon request. Silence can be interpreted as an attempt to conceal the weapon illegally, leading to suspicion and potential charges. Another incorrect approach is to only present the CWP when asked, without verbally acknowledging the firearm. While presenting the permit is required, the statute also implies a duty to identify oneself and the presence of the weapon. Failing to verbally confirm the firearm's presence can still create an element of surprise for the officer, potentially increasing tension and the risk of a misinterpretation of intent. A further incorrect approach is to argue with the officer about the legality of carrying a concealed weapon before disclosing its presence. This demonstrates a lack of understanding of the immediate legal requirements and escalates the interaction unnecessarily. The priority is to comply with the officer's lawful requests and the specific statutes governing concealed carry in Arizona, not to engage in a debate about rights at that moment. Professional reasoning. Professionals should approach such encounters with a clear understanding of ARS Section 13-3102(p). The decision-making process should prioritize immediate, transparent compliance with legal disclosure requirements. This involves recognizing the officer's authority, understanding the specific legal mandate to inform and present the permit, and acting proactively to de-escalate the situation. If unsure about specific nuances, the safest course of action is always to err on the side of full disclosure and compliance with the letter of the law. Question 5. The monitoring system demonstrates that an Arizona Concealed Weapons Permit (CWP) holder has entered a private business that has posted signage indicating that firearms are prohibited on the premises, but the specific wording of the signage is ambiguous regarding whether it applies to individuals with a valid CWP. The permit holder is unsure if their CWP exempts them from this specific signage. What is the most appropriate course of action for the permit holder in this situation, considering Arizona Revised Statutes related to concealed carry? Option A. Contact the Arizona Department of Public Safety for clarification on the applicability of the signage to CWP holders. Option B. Assume the signage applies to all individuals, including CWP holders, and leave the premises immediately. Option C. Proceed with carrying the concealed weapon, believing that a CWP supersedes any private business's signage. Option D. Rely on personal interpretation of the signage and the general understanding of CWP privileges to determine if carrying is permissible. The correct answer is A. Contact the Arizona Department of Public Safety for clarification on the applicability of the signage to CWP holders. Explanation. Scenario analysis. This scenario is professionally challenging because it requires an individual to balance their right to self-defense with the legal obligations and responsibilities associated with carrying a concealed weapon in Arizona. The core challenge lies in interpreting and applying Arizona Revised Statutes, ARS, related to concealed carry, specifically ARS Section 13-3102, which governs the requirements and restrictions for a permit. Misinterpreting these statutes can lead to serious legal consequences, including criminal charges and the revocation of a concealed weapons permit. The situation demands a thorough understanding of when and where carrying a concealed weapon is permissible, and the specific conditions that might negate those permissions. Correct approach analysis. The best professional approach involves a direct and proactive engagement with the Arizona Department of Public Safety, DPS, to clarify the specific circumstances and obtain official guidance. This approach is correct because ARS Section 13-3102(p) explicitly states that a person who is issued a permit to carry a concealed weapon is not required to obtain a permit to carry a loaded firearm in a vehicle. However, the statute also outlines numerous locations where carrying a concealed weapon is prohibited, regardless of a permit. When faced with ambiguity regarding a specific location or situation not explicitly covered by the statute's prohibitions, seeking clarification from the issuing authority, Arizona DPS, is the most responsible and legally sound action. This ensures compliance with the law and avoids potential violations. Incorrect approach is analysis. One incorrect approach is to assume that having a valid concealed weapons permit automatically grants unrestricted carry privileges in all public spaces, including those where specific prohibitions are outlined in ARS Section 13-3102. This fails to acknowledge the detailed list of restricted locations, such as schools, courthouses, and polling places, which are clearly defined in the statute. Relying solely on the permit without understanding these limitations is a direct violation of the law. Another incorrect approach is to interpret the statute based on personal opinion or anecdotal information from other permit holders. Laws are precise, and their interpretation must be grounded in the statutory language and official guidance. Relying on informal advice can lead to misinterpretations and subsequent legal trouble, as the responsibility for understanding and adhering to the law rests solely with the permit holder. A further incorrect approach is to avoid carrying the weapon altogether due to uncertainty, even if the location is not explicitly prohibited by statute. While this might seem like a safe option to avoid legal issues, it fails to address the individual's right to self-defense as protected by Arizona law, provided they are acting within the legal framework for concealed carry. The goal is to understand and comply with the law, not to abandon a legal right due to a lack of clarity that could be resolved through proper channels. Professional reasoning. Professionals in possession of a concealed weapons permit in Arizona should adopt a proactive and informed approach to legal compliance. This involves 1. Thoroughly understanding the provisions of ARS Section 13-3102, paying close attention to both the rights granted and the specific prohibitions. 2. When encountering ambiguity regarding a location or situation, prioritizing official clarification from the Arizona Department of Public Safety over personal interpretation or informal advice. 3. Maintaining a clear understanding of the responsibilities that accompany the privilege of carrying a concealed weapon, including the duty to know and abide by all applicable laws. This systematic approach ensures responsible firearm ownership and adherence to legal requirements. Question 6. The monitoring system demonstrates a permit holder in Arizona is being verbally harassed and intimidated by an individual in a public parking lot. The aggressive individual is standing close, making aggressive gestures and shouting insults, but has not physically touched the permit holder or made any direct threats of physical violence. The permit holder feels increasingly threatened and is concerned about their safety. What is the most appropriate and legally sound course of action for the permit holder under Arizona law? Option A. Immediately draw the concealed firearm and aim it at the aggressive individual to ensure your safety. Option B. Display the concealed firearm to the aggressive individual to deter further intimidation. Option C. Verbally confront the aggressive individual and inform them that you are legally armed. Option D. Disengage from the confrontation by walking away and, if necessary, contacting law enforcement to report the harassment. The correct answer is D. Disengage from the confrontation by walking away and, if necessary, contacting law enforcement to report the harassment. Explanation. Scenario analysis. This scenario is professionally challenging because it requires an individual to balance their right to self-defense with the legal obligations and responsibilities associated with carrying a concealed weapon in Arizona. Misinterpreting or disregarding the nuances of Arizona revised statutes, ARS, concerning concealed carry can lead to severe legal consequences, including criminal charges and the revocation of a permit. The core challenge lies in understanding the scope of permissible actions when a permit holder feels threatened, particularly in situations that may not immediately escalate to physical violence, but involve perceived intimidation or harassment. Correct approach analysis. The best professional approach involves understanding that an Arizona Concealed Weapons Permit, CWP, primarily grants the right to carry a concealed firearm. It does not grant the right to brandish or threaten with a firearm in situations that do not meet the legal threshold for self-defense. Therefore, the correct response is to disengage from the confrontation and report the incident to law enforcement if necessary. This approach aligns with ARS, Section 13-3102, which outlines the requirements and restrictions for carrying a concealed weapon. While the statute permits carrying a concealed weapon, it does not authorize its use as a tool for intimidation or to resolve non-imminent threats. Prioritizing de-escalation and avoiding any action that could be construed as aggressive or threatening, even when feeling threatened, is paramount. Reporting the incident allows law enforcement to assess the situation and take appropriate action, while the permit holder avoids potentially unlawful use of their firearm. Incorrect approach is analysis. One incorrect approach is to display the firearm to deter the aggressive individual. This action, even if motivated by a desire to de-escalate or protect oneself, can be interpreted as brandishing a weapon, which is a criminal offense in Arizona under ARS. Section 13-3102, A3, if done in a manner that causes fear of imminent harm. The permit holder's perception of threat does not automatically justify displaying the weapon. The threat must be imminent and deadly to warrant such a response under self-defense laws. Another incorrect approach is to verbally confront the aggressive individual and inform them that you are legally armed. While it might seem like a way to assert authority or deter further aggression, this can escalate the situation and potentially lead to the permit holder being perceived as the aggressor. Arizona law does not require or encourage informing others of your concealed weapon status in such a scenario, and doing so can create unnecessary tension and risk. A further incorrect approach is to immediately draw the firearm and aim it at the aggressive individual. This is a severe misinterpretation of self-defense laws and the purpose of a CWP. Drawing and aiming a firearm is an action that implies an imminent threat of death or serious bodily harm, and if such a threat is not present, this action itself can be considered unlawful use of a deadly weapon and lead to criminal charges, irrespective of the permit. Professional reasoning. Professionals carrying a concealed weapon in Arizona must adopt a decision-making process that prioritizes de-escalation and adherence to legal statutes. This involves 1. Threat assessment. Continuously assess the imminence and severity of any perceived threat. Is the threat immediate and life-threatening, or is it a situation that can be avoided or de-escalated? 2. Legal boundaries. Understand that a CWP is for carrying, not for intimidation or preemptive action. Familiarize oneself with ARS Section 13-3102 and Self-Defense Statutes ARS Section 13-404, Section 13-405. 3. De-escalation and disengagement. The primary goal should be to avoid confrontation. If confronted, disengage from the situation if possible. 4. Reporting. If the situation warrants it, report the incident to law enforcement after disengaging. 5. Use of force. Only consider drawing or using a firearm as a last resort when facing an imminent threat of death or serious bodily harm, in accordance with Arizona law. Question 7. Risk assessment procedures indicate that while legally carrying a concealed weapon under an Arizona Concealed Weapons Permit, CWP, in a public park, you observe a group of individuals behaving disruptively and speaking loudly in your general direction, causing you to feel uneasy. What is the most appropriate immediate course of action to maintain legal compliance and personal safety? Option A. Discreetly and safely secure the firearm without drawing attention, while continuing to observe the situation for any actual threat and preparing to de-escalate or disengage if possible. Option B. Draw the firearm and hold it in a ready position to deter the individuals from approaching further. Option C. Immediately confront the individuals, identify yourself as a permit holder, and demand they cease their disruptive behavior. Option D. Announce loudly that you are legally armed and have a permit to carry a concealed weapon. The correct answer is A. Discreetly and safely secure the firearm without drawing attention, while continuing to observe the situation for any actual threat and preparing to de-escalate or disengage if possible. Explanation. Scenario analysis. This scenario is professionally challenging because it requires an individual to balance their right to self-defense with the strict legal requirements for carrying a concealed weapon in Arizona. The challenge lies in interpreting and applying Arizona Revised Statutes, A.R.S. Section 13-3112, which governs concealed carry, in a situation where immediate perceived threat might lead to impulsive actions. A careful judgment is required to ensure compliance with the law while maintaining personal safety. Correct approach analysis. The best professional practice involves immediately ceasing any action that could be construed as brandishing or displaying the firearm, and then discreetly and safely securing the weapon in a manner that does not draw attention or cause alarm, while simultaneously assessing the situation for any actual threat. This approach is correct because A.R.S. Section 13-3112G explicitly states that a person with a valid permit may carry a concealed weapon, but it does not grant permission to display or brandish the weapon unnecessarily. The primary ethical and legal obligation is to carry concealed, meaning it should not be visible. Drawing or displaying the weapon without an immediate, justifiable threat of death or serious bodily injury is a violation of the permit's conditions and potentially state law. This approach prioritizes de-escalation and legal compliance. Incorrect approach is analysis. One incorrect approach involves drawing the firearm and holding it in a ready position while observing the individuals. This is professionally unacceptable because it constitutes displaying a deadly weapon without an immediate threat, which is a violation of A.R.S. Section 13-3112 and can escalate a situation unnecessarily, potentially leading to legal repercussions or unintended harm. Another incorrect approach is to immediately confront the individuals and demand they leave the area. This is professionally unacceptable as it goes beyond the scope of a concealed carry permit, which is for self-defense, not for law enforcement or public order enforcement. Such an action could be interpreted as provocation and may lead to a confrontation that could have been avoided, violating the principle of responsible firearm carriage. A third incorrect approach is to leave the firearm in its concealed location, but loudly announce that you are armed and legally permitted to carry. This is professionally unacceptable because it defeats the purpose of concealed carry and can cause undue alarm and panic among other patrons, potentially creating a dangerous situation. It also draws unnecessary attention to the firearm and the permit holder, which is contrary to the discreet nature of concealed carry. Professional reasoning. Professionals facing such situations should employ a decision-making framework that prioritizes de-escalation, legal compliance, and situational awareness. First, assess the immediate environment and the nature of the perceived threat. Second, recall and apply relevant statutes, such as A.R.S. Section 13-3112, focusing on the conditions and limitations of the permit. Third, consider the ethical implications of any action, aiming to avoid unnecessary escalation or alarm. Fourth, if a threat is imminent and unavoidable, act within the bounds of self-defense law. If the situation does not warrant immediate defensive action, the priority should be to disengage or discreetly remove oneself from the situation if possible, without drawing attention to the firearm. Question 8. Stakeholder feedback indicates that designated protidor NUS officers, DPO in Arizona, sometimes face situations where a concealed weapons permit CWP applicant has disclosed a past arrest for disorderly conduct, but no conviction resulted from that incident. Considering the requirements of Arizona Revised Statutes, Rs. Section 13-3112, which outlines the grounds for CWP denial, what is the most appropriate course of action for a DPO when presented with such an application? Option A. Approve the application without further investigation, assuming that the absence of a conviction renders the arrest irrelevant to CWP eligibility. Option B. Immediately deny the application based on the self-reported arrest for disorderly conduct, as any interaction with law enforcement suggests a potential risk. Option C. Conduct a thorough review of the applicant's self-disclosure and cross-reference it with available law enforcement records to determine if the arrest or any related circumstances warrant denial under ARS Section 13-3112. Option D. Contact the applicant's current employer to inquire about their general behavior and suitability for carrying a concealed weapon. The correct answer is C. Conduct a thorough review of the applicant's self-disclosure and cross-reference it with available law enforcement records to determine if the arrest or any related circumstances warrant denial under ARS Section 13-3112. Explanation. Scenario analysis. This scenario presents a professional challenge due to the sensitive nature of concealed weapons and the legal responsibilities associated with permit applications. A CWP applicant's past behavior, even if not resulting in a conviction, can raise concerns about their suitability to carry a concealed weapon. The designated protidor, NUS officer DPO, must balance the applicant's right to apply with the public safety mandate of the Arizona CWP program. This requires careful consideration of all provided information and adherence to Arizona Revised Statutes, Rs, governing CWP issuance. Correct approach analysis. The best professional practice involves a thorough review of all submitted documentation, including the applicant's self-disclosure of past incidents, and cross-referencing this information with available law enforcement records. This approach directly addresses the requirements of ARS Section 13-3112, which outlines the grounds for denial of a CWP. Specifically, the statute requires the Department of Public Safety to consider any history of certain dangerous or violent offenses, or any history of alcohol or drug abuse that would be grounds for denial. A comprehensive review ensures that the DPO is making an informed decision based on all relevant facts and legal criteria, rather than making assumptions or overlooking critical details. This upholds the integrity of the CWP process and prioritizes public safety. Incorrect approaches analysis. One incorrect approach is to immediately deny the application solely based on the applicant's self-reported arrest for disorderly conduct, without further investigation. This fails to acknowledge that an arrest does not equate to a conviction, and that ARS Section 13-3112 specifies grounds for denial based on convictions or specific types of behavior, not mere arrests without context or disposition. This approach could lead to an unlawful denial and potential legal challenge. Another incorrect approach is to approve the application without any further inquiry into the disorderly conduct arrest, assuming that since no conviction resulted, it is irrelevant. This overlooks the DPO's duty to assess the applicant's overall suitability and potential risk. The statute allows for consideration of a broader range of factors that might indicate a propensity for violence or instability, even if not resulting in a conviction. Ignoring potentially relevant information compromises public safety. A third incorrect approach is to contact the applicant's employer to inquire about their general demeanor and job performance. This is an overreach of authority and a violation of privacy. The DPO's investigation should be limited to information directly relevant to the CWP application criteria, as outlined in ARS Section 13-3112, and publicly accessible law enforcement records. Inquiring about unrelated employment matters is not a permissible investigative step. Professional reasoning. Professionals in this role must adopt a systematic and legally compliant decision-making process. This involves 1. Understanding the specific statutory requirements for CWP issuance and denial in Arizona. 2. conducting a thorough and objective review of all submitted application materials. 3. Utilizing authorized investigative channels to verify information and gather relevant facts, such as checking law enforcement databases for arrest and conviction records. 4. Applying the legal criteria for denial consistently and without bias. 5. Documenting all investigative steps and the rationale for the final decision. This structured approach ensures fairness to the applicant while fulfilling the DPO's responsibility to protect the public. Question 9. The evaluation methodology shows that an Arizona Concealed Weapons Permit (CWP) holder is attending a public high school's evening football game as a spectator. The individual is not a student, faculty member, or employee of the school. Considering Arizona law, what is the most appropriate course of action regarding the concealed firearm? Option A. Assume personal protection needs supersede location-based restrictions and carry the concealed firearm into the stadium. Option B. Carry the concealed firearm into the stadium, as the individual is a permit holder and not directly affiliated with the school. Option C. Secure the firearm in the vehicle before entering the stadium. Option D. Carry the firearm openly, as this is permissible in Arizona and bypasses concealed carry restrictions. Correct answer is C. Secure the firearm in the vehicle before entering the stadium. Explanation. The evaluation methodology shows that this scenario is professionally challenging due to the inherent tension between an individual's right to self-defense and the state's interest in public safety, as codified by Arizona law. A concealed weapon permit holder must exercise extreme discretion and adhere strictly to legal parameters to avoid criminal charges and maintain their permit. The scenario requires a nuanced understanding of when and where the carrying of a concealed weapon is permissible and the legal ramifications of exceeding those boundaries. The correct approach involves understanding that Arizona law, specifically Arizona Revised Statutes, A.R.S. Section 13-3102, outlines specific locations where carrying a concealed weapon is prohibited, even with a valid permit. This includes, but is not limited to, schools, courthouses, and correctional facilities. The correct response is to recognize that attending a public school event, even if the individual is not a student or employee, falls under these prohibited areas due to the presence of minors and the general safety concerns associated with educational institutions. Therefore, leaving the weapon secured in the vehicle is the only legally compliant action. This approach prioritizes adherence to the law, ensuring public safety, and preventing potential legal entanglements. An incorrect approach would be to assume that because the individual is a permit holder and not directly involved with the school's operations, the prohibition does not apply. This demonstrates a failure to grasp the scope of A.R.S. Section 13-3102, which broadly restricts carrying firearms in schools. Another incorrect approach would be to carry the weapon openly, believing this negates the concealed carry prohibition. However, Arizona law has specific regulations regarding open carry as well, and the primary issue here is the location itself. Furthermore, a flawed approach would be to rationalize that personal protection is paramount and overrides the location-based restrictions, ignoring the legal framework designed to balance individual rights with community safety. This demonstrates a disregard for the law and a potentially dangerous misjudgment of legal boundaries. Professionals should employ a decision-making framework that begins with a thorough understanding of the relevant statutes and regulations governing their actions. This involves proactively educating oneself on prohibited locations and circumstances for carrying a concealed weapon. When faced with a situation where the legality of carrying a weapon is uncertain, the safest and most legally sound decision is to err on the side of caution, which in this case means securing the weapon in a legally permissible manner, such as in a vehicle, rather than risking a violation. This proactive and cautious approach minimizes legal risk and upholds the principles of responsible firearm ownership. Question 10. Regulatory review indicates that an applicant for an Arizona Concealed Weapons Permit (CWP) has completed a firearm safety course that lasted 6 hours and covered all the topics mandated by Arizona Revised Statute Section 13-3112. The applicant is now enrolling in a new CWP course that is 8 hours long and also covers all mandated topics. If the applicant successfully completes the new 8-hour course, what is the minimum total number of hours of approved training the applicant will have completed, and how many additional hours, if any, beyond the statutory minimum of 8 hours will they have completed? Option A. the applicant will have completed a total of 8 hours of approved training, meeting the statutory minimum exactly, with 0 hours beyond the statutory minimum. Option B. The applicant will have completed a total of 14 hours of approved training, with 6 hours beyond the statutory minimum. Option C. The applicant will have completed a total of 8 hours of approved training, with 2 hours beyond the statutory minimum. Option D. The applicant will have completed a total of 10 hours of approved training, with 2 hours beyond the statutory minimum. The correct answer is A. The applicant will have completed a total of 8 hours of approved training, meeting the statutory minimum exactly, with 0 hours beyond the statutory minimum. Explanation. Scenario analysis. This scenario presents a professional challenge in accurately calculating the required training hours for a concealed weapons permit (CWP) applicant in Arizona, given varying course lengths and potential credit for prior experience. Miscalculation can lead to either an applicant being denied a permit due to insufficient training, or the state issuing a permit to someone who hasn't met the minimum legal requirements, both of which have significant legal and safety implications. The professional must navigate the specific statutory requirements for training hours and apply them correctly to the applicant's situation. Correct approach analysis. The best professional practice involves a precise calculation of the minimum required training hours based on Arizona Revised Statutes, A.R.S. Section 13-3112. This statute mandates a minimum of 8 hours of training, which must include specific topics. If an applicant claims credit for prior training, the professional must verify that the prior training meets or exceeds the content and duration requirements of A.R.S. Section 13-3112. If the prior training is insufficient in duration, the applicant must complete the difference to reach the 8-hour minimum. In this case, the applicant's prior training of 6 hours is less than the statutory 8-hour minimum. Therefore, the applicant must complete an additional 2 hours of approved training to meet the requirement. The total required training is 8 hours, and the applicant has completed 6 hours, necessitating 2 more hours. Incorrect approach is analysis. One incorrect approach is to accept the applicant's prior 6 hours of training as sufficient because it covered the required topics, even though it fell short of the statutory 8-hour duration. This fails to adhere to the explicit minimum hour requirement set forth in A.R.S. Section 13-3112, potentially allowing an inadequately trained individual to obtain a permit. Another incorrect approach is to simply add the 6 hours of prior training to the 4 hours of the new course, resulting in 10 hours, and deeming it sufficient without considering that the statutory minimum is 8 hours and the prior training itself was deficient. While the total hours exceed the minimum, the initial deficiency in the prior training must be addressed to meet the spirit and letter of the law, which requires a comprehensive 8-hour block of instruction or its equivalent. A third incorrect approach is to require the applicant to complete the full 8 hours of the new course, disregarding the 6 hours of prior training entirely. While this would ensure the applicant receives 8 hours of training, it is not the most efficient or equitable application of the law if the prior training was legitimate and covered the necessary topics, even if it was shorter. The law allows for credit for prior training, and the professional's duty is to assess its equivalency and supplement as needed, not to discard it arbitrarily. Professional reasoning. Professionals must adopt a systematic approach. First, identify the specific statutory requirements for CWP training in Arizona A.R.S. Section 13-3112. Second, meticulously evaluate any claimed prior training against these statutory requirements, focusing on both content and duration. Third, perform precise calculations to determine any deficit in training hours. Finally, ensure that the applicant completes the minimum required hours, either through prior training or by supplementing with additional approved instruction, to comply with the law and uphold public safety. Question 11. Performance analysis shows that a concealed weapons permit holder in Arizona is entering an establishment that is clearly a bar, with patrons consuming alcoholic beverages. No signage is visible at the entrance or within the establishment. What is the most prudent course of action for the permit holder to ensure compliance with Arizona law? Option A. Carry the concealed weapon into the establishment, assuming that the absence of a statutorily compliant sign permits concealed carry. Option B. Seek verbal permission from a bartender or manager before carrying the concealed weapon into the establishment. Option C. Carry the concealed weapon into the establishment and be prepared to leave immediately if asked to do so by staff. Option D. Do not carry the concealed weapon into the establishment, as it is primarily devoted to the sale of alcoholic beverages for consumption on the premises, irrespective of signage. Correct answer is D. Do not carry the concealed weapon into the establishment, as it is primarily devoted to the sale of alcoholic beverages for consumption on the premises, irrespective of signage. Explanation: performance analysis shows that a common challenge for Arizona concealed weapons permit (CWP) holders involves understanding the nuances of carrying a firearm in private establishments that serve alcohol, particularly when signage is present. This scenario is professionally challenging because it requires a precise interpretation of Arizona Revised Statutes, ARS. Section 13-3102, which governs the places where a CWP holder may not carry a concealed firearm. The presence of a sign, even if not perfectly compliant with all statutory requirements, can create ambiguity and potential legal ramifications for the permit holder. Careful judgment is required to avoid unintentional violations. The best professional approach involves a thorough understanding and strict adherence to Arizona law regarding prohibited places. This means recognizing that ARS. Section 13-3102, A8, specifically prohibits carrying a concealed weapon in a bar or other establishment that is primarily devoted to the sale of alcoholic beverages for consumption on the premises. The law also addresses signage, stating that a person is not prohibited from carrying a concealed weapon in such an establishment if the establishment has not posted a sign that is conspicuously visible to the public and at least 36 inches by 36 inches in size, and that clearly states no firearms allowed. Therefore, the correct approach is to avoid carrying a concealed weapon in any establishment that is primarily devoted to the sale of alcoholic beverages for consumption on the premises, regardless of whether a specific sign is posted, as the statutory prohibition is based on the nature of the establishment itself. An incorrect approach would be to assume that the absence of a specific, statutorily compliant sign means it is permissible to carry a concealed weapon in an establishment primarily devoted to the sale of alcohol. This fails to recognize that the primary prohibition is tied to the nature of the establishment, not solely the presence or absence of a sign. Another incorrect approach would be to rely on informal verbal permission from an employee or owner, as this does not override the statutory prohibition. Finally, an approach that involves carrying a concealed weapon in such an establishment and then claiming ignorance of the law or the nature of the establishment is also professionally unacceptable, as it demonstrates a lack of due diligence and responsibility expected of a CWP holder. Professionals should employ a decision-making framework that prioritizes understanding and compliance with all applicable statutes. This involves proactively researching and understanding the specific prohibitions outlined in ARS. Section 13-3102, particularly concerning establishments that serve alcohol. When in doubt about the permissibility of carrying a firearm in a particular location, the safest and most legally sound decision is to refrain from carrying the weapon in that location. This proactive approach minimizes risk and upholds the responsibilities associated with holding a CWP. Question 12. The control framework reveals an applicant for an Arizona Concealed Weapons Permit, CWP, has a prior conviction for a misdemeanor involving domestic violence. Considering Arizona Revised Statute Section 13-3102, which of the following actions best reflects a professional and legally compliant approach to evaluating this applicant's eligibility? Option A. Assume that any misdemeanor conviction, including those involving domestic violence, permanently disqualifies an individual from obtaining an Arizona CWP without further investigation into the specifics. Option B. Issue the CWP immediately if the applicant appears to be a law-abiding citizen in all other respects, without a detailed examination of the domestic violence conviction's details and statutory implications. Option C. Automatically deny the CWP application upon learning of any conviction related to domestic violence, regardless of the conviction date or specific statute violated. Option D. Thoroughly review the specific statute under which the applicant was convicted for domestic violence, the exact date of the conviction, and determine if the conviction falls within the 7-year look-back period specified in ARS. Section 13-3102, A5, to assess eligibility. The correct answer is D. Thoroughly review the specific statute under which the applicant was convicted for domestic violence, the exact date of the conviction, and determine if the conviction falls within the 7-year look-back period specified in ARS Section 13-3102. A. 5. To assess eligibility. Explanation. The control framework reveals a scenario where an applicant for an Arizona Concealed Weapons Permit, CWP, has a past conviction for a misdemeanor involving domestic violence. This presents a professional challenge because the applicant's eligibility hinges on a precise interpretation of Arizona revised statutes, ARS. Section 13-3102, which governs CWP qualifications. The challenge lies in distinguishing between disqualifying offenses and those that may not automatically preclude an applicant, requiring a nuanced understanding of the law and its application to specific factual circumstances. Careful judgment is required to ensure compliance with state law and to uphold the integrity of the permitting process. The best professional practice involves a thorough review of the applicant's criminal history against the specific disqualifying criteria outlined in ARS Section 13-3102. This includes verifying the exact nature of the offense, the date of conviction, and whether it falls under the definition of a prohibited offense as defined by Arizona law, particularly concerning domestic violence. If the conviction is for a misdemeanor domestic violence offense, it is crucial to determine if it is a disqualifying offense under ARS. Section 13-3102, A.5, which prohibits issuance to individuals convicted of a misdemeanor involving domestic violence within the preceding 7 years. A diligent approach would involve confirming the specific statute violated and the date of the conviction to ascertain if the 7-year look-back period has expired. If the conviction predates the 7-year period and meets other statutory requirements, the applicant may be eligible. This approach prioritizes strict adherence to statutory language and factual accuracy, ensuring a legally sound decision. An incorrect approach would be to automatically deny the permit solely based on the mention of domestic violence without further investigation. This fails to acknowledge that ARS. Section 13-3102, A.5, has a specific 7-year look-back period for such misdemeanors. Failing to verify the conviction date and the exact nature of the offense constitutes a regulatory failure, as it bypasses the statutory requirements for eligibility. Another incorrect approach would be to assume that any conviction, regardless of its nature or age, automatically disqualifies an applicant. This demonstrates a lack of understanding of the specific provisions within ARS. Section 13-3102 that outline which offenses and timeframes lead to disqualification. This overbroad interpretation is a regulatory failure because it does not apply the law as written. A third incorrect approach would be to grant the permit without a comprehensive review of the conviction details, relying on a superficial understanding of the applicant's record. This is a significant ethical and regulatory failure, as it compromises public safety and the integrity of the CWP system by potentially issuing a permit to an individual who may not meet the legal qualifications. The professional reasoning process for similar situations should involve a systematic approach. First, identify the relevant statutory provisions governing CWP eligibility in Arizona, specifically ARS. Section 13-3102. Second, meticulously gather all factual information regarding the applicant's criminal history, including the specific offense, statute violated, and conviction date. Third, compare these facts directly against the statutory criteria, paying close attention to any look-back periods or specific definitions of disqualifying offenses. Finally, document the entire review process and the rationale for the decision to ensure transparency and accountability. Question 13. Stakeholder feedback indicates that applicants for an Arizona Concealed Weapons Permit, CWP, sometimes struggle with how to accurately report past legal issues. Considering Arizona Revised Statute Section 13-3112, which governs the eligibility and application process for a CWP, how should an applicant who was previously convicted of a misdemeanor offense, for which the record has since been expunged, respond to a question on the CWP application form that asks, "Have you ever been convicted of a crime?" Option A, state that they have no criminal convictions because the record has been expunged. Option B, provide a detailed account of the circumstances surrounding the misdemeanor conviction and its expungement. Option C. Truthfully state that they were convicted of a misdemeanor offense and that the record has since been expunged. Option D. State that the conviction is irrelevant because it was expunged and therefore does not impact their eligibility. Correct answer is C. Truthfully state that they were convicted of a misdemeanor offense and that the record has since been expunged. Explanation. Scenario analysis. This scenario is professionally challenging because it requires an applicant to navigate potentially sensitive personal information and understand the nuances of Arizona law regarding the disclosure of such information in the context of a concealed weapons permit application. The applicant's past, even if resolved, can be a point of contention, and the permit-issuing authority has a duty to assess risk while respecting privacy rights. Careful judgment is required to ensure compliance with Arizona revised statutes, A.R.S. Section 13-3112, without oversharing or withholding crucial information. Correct approach analysis. The best professional practice involves providing a truthful and complete answer to the specific question asked on the application form, while also being prepared to offer further clarification if requested by the permitting authority. This approach directly addresses the application's requirement for disclosure of relevant information concerning past legal entanglements that could impact permit eligibility under ARS Section 13-3112. By truthfully stating the conviction and its subsequent expungement, the applicant demonstrates honesty and transparency, which are critical for trust with law enforcement and the permitting agency. This aligns with the ethical obligation to provide accurate information on official documents and the legal requirement to disclose information as mandated by the statute, even if the record has been sealed or expunged, as the underlying event may still be relevant to the permitting authority's assessment. Incorrect approach is analysis. Providing no information about the past conviction, even if expunged, is a regulatory failure. While expungement may remove certain civil disabilities, it does not necessarily absolve an applicant from disclosing the underlying event if the permitting authority, under ARS Section 13-3112, requires such disclosure for the purpose of assessing eligibility. This omission can be construed as an attempt to mislead the authority. Stating that the conviction was expunged and therefore irrelevant without providing any details about the conviction itself is also a regulatory failure. The permitting authority has the discretion to determine what is relevant to the issuance of a permit. Simply dismissing the conviction as irrelevant bypasses this authority and may be seen as uncooperative or evasive. Providing an overly detailed and unsolicited narrative about the circumstances surrounding the conviction, including personal justifications or emotional appeals, is an ethical and practical misstep. While honesty is paramount, the application form likely has specific fields for such information. Unsolicited extensive detail can be perceived as an attempt to unduly influence the decision maker or may introduce irrelevant information that distracts from the core requirements of the application, potentially raising concerns about judgment. Professional reasoning. Professionals should approach permit applications by meticulously reviewing the application form and understanding the specific questions asked. They must then consult the relevant statutes, in this case, ARS Section 13-3112, to understand the legal requirements for disclosure. The decision-making process should prioritize honesty, completeness, and adherence to the specific instructions of the application and the governing law. When in doubt about the scope of disclosure, it is prudent to err on the side of providing more relevant information and being prepared to explain it, rather than withholding potentially discoverable information. Question 14. Stakeholder feedback indicates a need to clarify the scope of an Arizona concealed weapons permit instructor's responsibilities when an applicant expresses significant personal fear of a specific individual and a strong desire to carry a firearm for protection. Considering Arizona revised statutes, what is the most appropriate course of action for the instructor regarding their recommendation for the applicant's permit? Option A. Recommend denial if the applicant appears nervous or unprepared during the training, as this might indicate they are not responsible enough to carry a concealed weapon. Option B. Recommend denial based on the applicant's expressed fear of a specific individual, as this suggests a potential for future conflict that the instructor deems too risky. Option C. Recommend approval if the applicant demonstrates a thorough understanding of Arizona's concealed carry laws and meets all other statutory requirements outlined in ARS Section 13-3112, regardless of their personal fears or the perceived threat. Option D. Recommend approval solely because the applicant expresses a strong desire for self-defense, assuming their fear validates their need for a permit. Correct answer is C. Recommend approval if the applicant demonstrates a thorough understanding of Arizona's concealed carry laws and meets all other statutory requirements outlined in ARS Section 13-3112, regardless of their personal fears or the perceived threat. Explanation. Scenario analysis. This scenario presents a professional challenge for a CWP instructor in Arizona because it involves balancing the applicant's perceived need for self-defense with the strict legal requirements for obtaining a permit. The instructor must ensure that their recommendation is based solely on the applicant's adherence to Arizona Revised Statutes (ARS) concerning concealed carry, not on subjective interpretations of their personal circumstances or perceived threats. Failure to do so could result in the issuance of a permit to an unqualified individual, potentially compromising public safety, or unjustly denying a permit to a qualified applicant. Correct approach analysis. The best professional practice is to base the recommendation solely on the applicant's demonstrated understanding of and compliance with Arizona Revised Statutes pertaining to concealed carry, including ARS Section 13-3112, which outlines the requirements for obtaining a permit. This approach ensures that the instructor is acting within the legal framework, upholding the integrity of the permitting process, and fulfilling their duty to assess the applicant's qualifications as defined by state law. The instructor's role is to verify legal eligibility, not to act as a judge of personal circumstances or perceived threats beyond what is legally stipulated. Incorrect approaches analysis. Recommending denial based on the applicant's expressed fear of a specific individual, without evidence that this fear constitutes a disqualifying factor under ARS Section 13-3112, such as a restraining order or a documented history of threats that would lead to a disqualification, is an overreach of the instructor's authority. The instructor is not empowered to make subjective judgments about the validity of an applicant's fears, or to deny a permit based on potential future conflicts not covered by statute. Similarly, recommending approval solely because the applicant expresses a strong desire to carry a weapon for self-defense, without a thorough assessment of their knowledge of relevant laws and their ability to meet all statutory requirements, bypasses the essential legal vetting process. Finally, recommending denial because the applicant seems nervous or unprepared is subjective and not tied to any specific statutory disqualification. The CWP program is designed to assess legal knowledge and adherence to specific criteria, not to gauge an applicant's general demeanor or perceived preparedness beyond what is legally mandated. Professional reasoning. Professionals in this role must adopt a decision-making framework rooted in strict adherence to the governing statutes. When evaluating an applicant for an Arizona concealed weapons permit, the primary focus must be on whether the applicant meets the objective criteria established by Arizona Revised Statutes. This involves verifying their age, residency, completion of required training, and absence of any disqualifying criminal history or mental health adjudications, as specified in ARS Section 13-3112. Subjective assessments of an applicant's personal circumstances, fears, or general demeanor should not influence the recommendation unless those circumstances directly relate to a specific statutory disqualification. The instructor's role is to be a gatekeeper of legal compliance, not a predictor of future behavior or a judge of personal safety concerns outside the legal framework. Question 15. Strategic planning requires a thorough assessment of an applicant's background when considering their eligibility for an Arizona Concealed Weapons Permit (CWP). An applicant discloses a prior conviction for aggravated assault that has since been expunged. What is the most appropriate course of action for the permitting authority in Arizona? Option A. Request a character reference from the applicant's employer to assess their current trustworthiness for carrying a concealed weapon. Option B. Automatically approve the permit because the conviction has been expunged, thereby restoring the applicant's civil rights. Option C. Deny the permit solely based on the existence of any prior felony conviction, regardless of its expungement status or the specific nature of the offense. Option D. Conduct a detailed review of the expunged record to determine if the underlying aggravated assault conviction qualifies as a disqualifying offense under Arizona Revised Statutes Section 13-3112, And if so, deny the permit. Correct answer is D. Conduct a detailed review of the expunged record to determine if the underlying aggravated assault conviction qualifies as a disqualifying offense under Arizona Revised Statute Section 13-3112, and if so, deny the permit. Explanation: strategic planning requires careful consideration of an applicant's history when evaluating their eligibility for an Arizona Concealed Weapons Permit, CWP. This scenario is professionally challenging because it involves balancing an individual's right to bear arms with the state's interest in public safety, necessitating a thorough understanding of Arizona Revised Statutes, Rs, related to firearm possession and permitting. The applicant's prior conviction for aggravated assault, even if expunged, raises significant concerns regarding their suitability to carry a concealed weapon. The best professional approach involves a comprehensive review of the applicant's entire criminal history, including any expunged or sealed records, to determine if the prior conviction disqualifies them under ARS Section 13-3112. This statute outlines specific disqualifying offenses, and while expungement may restore certain civil rights, it does not necessarily negate a disqualification for CWP eligibility if the underlying offense falls within the statutory prohibitions. A thorough investigation would involve verifying the nature of the aggravated assault charge and its classification under Arizona law to ascertain if it constitutes a felony or a crime of violence that would preclude CWP issuance. This approach prioritizes adherence to the specific disqualification criteria outlined in ARS Section 13-3112 and ensures that public safety is paramount. An incorrect approach would be to solely rely on the fact that the conviction was expunged and automatically approve the permit. This fails to acknowledge that ARS Section 13-3112 disqualifications are based on the nature of the offense itself, not solely on the current legal status of the conviction. Another incorrect approach would be to deny the permit solely based on the existence of any prior conviction, without a detailed examination of whether that specific conviction meets the statutory disqualification criteria. This could lead to an arbitrary denial and potential legal challenge. Finally, an approach that involves making a decision based on personal opinion or assumptions about the applicant's current character, without a rigorous review of the legal disqualifications, is professionally unsound and violates the principles of objective application of the law. Professionals should employ a decision-making framework that begins with a thorough understanding of the relevant statutes, specifically ARS Section 13-3112. This framework requires objective evaluation of all submitted documentation, including criminal history records, and a diligent investigation into any potentially disqualifying factors. The process should be guided by the principle of upholding public safety while respecting the rights of eligible individuals, ensuring that decisions are based on established legal criteria rather than subjective judgment. Question 16. The assessment process reveals an applicant for an Arizona Concealed Weapons Permit, CWP, demonstrates excellent marksmanship and firearm handling skills during the required range qualification. However, when questioned about the specific legal thresholds for using deadly force in self-defense as outlined in Arizona Revised Statutes, the applicant provides vague and uncertain answers, stating they assume they can use their weapon if they feel threatened. What is the most appropriate course of action for the certified instructor? Option A. Immediately fail the applicant, citing their lack of definitive knowledge regarding the use of deadly force and refuse to provide any further training or certification. Option B. Acknowledge the applicant's firearm proficiency, but inform them that they have not met the legal knowledge requirements for a CWP in Arizona and offer to provide additional instruction specifically on the statutes governing the use of deadly force. Option C. Proceed with certifying the applicant, emphasizing that the final determination of legal justification rests with the courts and focus solely on the demonstrated firearm proficiency. Option D. Advise the applicant that while their shooting skills are good, the instructor cannot assess their legal knowledge and recommend they seek legal counsel to understand self-defense laws before reapplying. The correct answer is C. Proceed with certifying the applicant, emphasizing that the final determination of legal justification rests with the courts and focus solely on the demonstrated firearm proficiency. Explanation: scenario analysis. This scenario presents a professional challenge for a concealed weapon permit instructor in Arizona. The challenge lies in balancing the applicant's stated intent to carry a firearm for self-defense with the instructor's ethical and legal obligations to ensure the applicant meets all statutory requirements for a permit. The instructor must not only assess the applicant's proficiency, but also their understanding of Arizona law regarding the use of deadly force and their eligibility. Misinterpreting or overlooking any of these aspects could lead to an unqualified individual obtaining a permit, potentially jeopardizing public safety and exposing the instructor to liability. Correct approach analysis. The best professional practice involves a comprehensive evaluation that directly addresses the applicant's understanding of Arizona Revised Statutes, RS. Section 13-411, Justifiable Use of Deadly Force, and ARS Section 13-3102, Carrying a Concealed Weapon. This approach requires the instructor to confirm the applicant's knowledge of when deadly force is legally permissible, as this is a fundamental component of responsible firearm ownership and concealed carry. It also necessitates verifying that the applicant meets all other statutory eligibility criteria, such as age and residency, and has demonstrated the required proficiency with a firearm. This holistic assessment ensures the applicant is not only capable of handling a firearm, but also understands the legal ramifications of carrying and using one in Arizona. Incorrect approaches analysis. One incorrect approach involves solely focusing on the applicant's marksmanship and firearm handling skills during the range qualification. While proficiency is a requirement, this approach fails to address the critical legal knowledge component mandated by Arizona law for concealed carry permits. An applicant could be an excellent shot, but lack the understanding of when their actions would be legally justified, leading to potential criminal charges even if the shooting was perceived as self-defense. Another incorrect approach is to assume that because the applicant states they intend to carry for self-defense, they automatically understand the legal parameters of using deadly force. This approach bypasses the instructor's duty to actively assess and confirm this knowledge, relying on an assumption rather than verification. Arizona law requires an understanding of justifiable use of force, and this cannot be presumed. It must be demonstrated or confirmed. A further incorrect approach is to overlook any potential disqualifying factors mentioned by the applicant, such as past legal issues, under the belief that the permitting agency will conduct its own background check and make the final determination. While the agency does conduct checks, the instructor has a responsibility to ensure the applicant appears to meet all statutory requirements as part of the training and assessment process. Failing to address potential red flags during the training phase is a dereliction of the instructor's duty to prepare the applicant for permit eligibility. Professional reasoning. Professionals in this field should adopt a systematic approach that integrates all statutory requirements. This involves 1. Thoroughly reviewing the Arizona Revised Statutes pertaining to concealed carry and the use of deadly force. 2. Designing training and assessment modules that explicitly test the applicant's comprehension of these laws. 3. Conducting a practical firearms proficiency test that meets or exceeds state standards. 4. Engaging in dialogue with the applicant to gauge their understanding of legal responsibilities and to identify any potential disqualifying factors. 5. Documenting all aspects of the training and assessment process. This structured methodology ensures compliance with legal mandates and upholds ethical standards in preparing individuals for the responsibility of carrying a concealed weapon. Question 17. Considering the Arizona Revised Statutes regarding concealed weapons permits, a permit holder notices that their chosen holster, while comfortable, sometimes allows the grip of their handgun to slightly protrude from their clothing when they bend over. What is the most responsible course of action to ensure compliance with Arizona law? Option A. Immediately cease using the current holster and acquire a new one that guarantees complete concealment of the firearm's grip under all normal movements, or adjust carrying position to ensure concealment. Option B. Continue using the current holster, assuming that as long as the firearm is not intentionally displayed, the slight protrusion is not a violation. Option C. Only be concerned about the firearm's concealment when in areas with heightened security or when anticipating potential threats. Option D. Rely on the fact that the firearm is legally permitted to be carried concealed, and that minor visibility issues are unlikely to be a concern for law enforcement. The correct answer is A. Immediately cease using the current holster and acquire a new one that guarantees complete concealment of the firearm's grip under all normal movements, or adjust carrying position to ensure concealment. Explanation: the risk matrix shows a moderate likelihood of a concealed weapon permit holder inadvertently displaying their firearm in a public place due to a clothing malfunction or accidental jostling. This scenario is professionally challenging because it requires balancing an individual's lawful right to carry a concealed weapon with the public's right to feel safe and secure. A permit holder's actions, even if unintentional, can have significant legal and social repercussions. Careful judgment is required to ensure compliance with Arizona Revised Statutes, A.R.S. Section 13-3102, which governs concealed carry. The best professional approach involves proactive measures to prevent accidental exposure. This includes regularly checking that concealed carry clothing and holsters are secure and appropriate for the activity, and being mindful of one's surroundings to avoid situations that could lead to accidental display. This approach aligns with the spirit of A.R.S. Section 13-3102, which permits concealed carry but expects responsible and discreet handling of the firearm. The emphasis is on maintaining the concealed nature of the weapon at all times, thereby respecting public order and safety. An approach that relies solely on the assumption that a permit holder will always be aware of their firearm's concealment, without taking any preventative steps, is professionally deficient. This overlooks the practical realities of everyday life and the potential for unforeseen circumstances. It fails to uphold the responsibility that comes with carrying a concealed weapon, potentially leading to a violation of the law if the firearm becomes visible. Another professionally unacceptable approach is to dismiss the possibility of accidental display as a minor inconvenience, believing that as long as the intent is not to openly display the weapon, no issue arises. This ignores the statutory requirement for the weapon to remain concealed and the potential for public alarm or misinterpretation, regardless of intent. Arizona law requires the weapon to be concealed, not just not intentionally displayed. Finally, an approach that suggests carrying the firearm in a manner that is easily accessible but not fully secured, with the justification that it allows for quicker reaction in a perceived threat, is also flawed. While accessibility is a consideration for permit holders, it must not compromise the fundamental requirement of concealment as mandated by A.R.S. Section 13-3102. Prioritizing immediate accessibility over consistent concealment creates an unacceptable risk of accidental exposure and potential legal ramifications. Professionals should employ a decision-making framework that prioritizes adherence to the letter and spirit of the law, coupled with a proactive and responsible approach to firearm safety and concealment. This involves understanding the specific requirements of Arizona's concealed carry laws, anticipating potential issues, and implementing practical measures to mitigate risks. Continuous self-assessment of carrying practices and awareness of the environment are crucial for maintaining compliance and public trust. Question 18. Stakeholder feedback indicates a concern among Arizona residents who previously received a misdemeanor conviction many years ago and are now seeking to obtain or maintain a concealed weapons permit, CWP. They are unsure if this past conviction, which was not a felony, would disqualify them under Arizona Revised Statutes. What is the most prudent and legally sound course of action for such an individual to ensure compliance with Arizona's concealed weapons laws? Option A. Proactively contact the Arizona Department of Public Safety, DPS, to inquire about the specific misdemeanor conviction and its potential impact on their CWP eligibility. Option B. Assume that any misdemeanor conviction from over 10 years ago is automatically irrelevant to CWP eligibility in Arizona. Option C. Proceed with carrying a concealed weapon under their CWP, assuming that the past misdemeanor is not a disqualifying factor unless explicitly informed otherwise by law enforcement. Option D. Rely on advice from firearm enthusiast groups or online forums to determine if the misdemeanor conviction affects their CWP. The correct answer is A. Proactively contact the Arizona Department of Public Safety, DPS, to inquire about the specific misdemeanor conviction and its potential impact on their CWP eligibility. Explanation: scenario analysis. This scenario is professionally challenging because it requires an applicant to navigate the nuances of Arizona's concealed weapons permit (CWP) laws, specifically concerning the definition of lawful possession and the implications of prior legal entanglements. A permit holder's understanding of these distinctions is crucial for maintaining compliance and avoiding legal repercussions. The challenge lies in interpreting how a past misdemeanor conviction, even if seemingly minor, might impact their current eligibility or the validity of their permit under Arizona revised statutes. Correct approach analysis. The best professional practice involves proactively seeking clarification from the Arizona Department of Public Safety, DPS, regarding the specific nature of the prior misdemeanor conviction and its potential impact on their CWP. This approach is correct because Arizona law, under ARS. Section 13-3112, outlines specific disqualifications for CWP eligibility, including certain felony convictions and other offenses. While the statute may not explicitly list every single misdemeanor, the DPS is the authoritative body responsible for interpreting and enforcing these statutes. Directly contacting them ensures the applicant receives accurate, jurisdiction-specific guidance based on the most current interpretations of the law, thereby upholding the principle of lawful possession and responsible firearm ownership as mandated by Arizona statutes. Incorrect approaches analysis. One incorrect approach is to assume that because the conviction was a misdemeanor and occurred many years ago, it automatically has no bearing on their CWP. This is a failure to adhere to the principle of due diligence and a misunderstanding of how prior convictions can affect firearm rights under Arizona law, which can be complex and subject to interpretation by the DPS. Another incorrect approach is to rely on informal advice from friends or online forums. This is professionally unacceptable as it bypasses the official channels for legal interpretation and can lead to misinformation, potentially resulting in a violation of Arizona's concealed carry laws. Such reliance ignores the specific regulatory framework established by the state. A further incorrect approach is to simply ignore the past conviction and proceed with carrying a concealed weapon without confirming its impact. This demonstrates a disregard for the legal requirements for obtaining and maintaining a CWP in Arizona and could lead to serious legal consequences, including permit revocation and criminal charges, directly contravening the spirit and letter of ARS. Section 13-3112. Professional reasoning. Professionals in this situation should always prioritize seeking official guidance from the relevant state agency when there is any ambiguity regarding legal requirements. This involves understanding the specific statutes governing their profession or activity, identifying potential areas of uncertainty, and then utilizing established channels for clarification. In the context of Arizona's CWP, this means consulting the Arizona DPS directly rather than making assumptions or relying on unverified information. This systematic approach ensures compliance, protects against legal pitfalls, and upholds the integrity of the permit system. Question 19. Operational review demonstrates that an Arizona concealed weapons permit (CWP) holder, while lawfully present in a retail establishment, observes another patron openly carrying a firearm. The CWP holder is aware that the establishment does not prohibit firearms. Considering Arizona law and best practices for responsible CWP holders, what is the most appropriate course of action? Option A. Discreetly and calmly exit the establishment. Option B. Immediately confront the patron about their firearm. Option C. Draw your own concealed weapon to assess the situation. Option D. Report the observation to the establishment's management or law enforcement without any indication of threat. Correct answer is A. Discreetly and calmly exit the establishment. Explanation. Scenario analysis. This scenario presents a professional challenge for a concealed weapon permit holder in Arizona who discovers a firearm in a location where they are legally permitted to carry. The challenge lies in navigating the nuances of Arizona law regarding the lawful possession of firearms in specific public spaces, particularly when encountering another individual's firearm. Careful judgment is required to avoid misinterpreting the law or acting in a manner that could lead to a misunderstanding or legal complication, while also ensuring personal safety and respecting the rights of others. Correct approach analysis. The best professional practice involves discreetly and calmly exiting the establishment. This approach is correct because Arizona law, under ARS. Section 13-3102, generally permits a person, with a valid concealed weapon permit to carry a concealed handgun in most public places. Discovering another individual's lawfully carried firearm does not, in itself, create a legal prohibition for the permit holder. The primary ethical and legal consideration is to avoid any action that could be perceived as confrontational or an escalation of a situation, and to remove oneself from a potentially uncomfortable or uncertain environment without drawing undue attention or creating a disturbance. This aligns with the principle of responsible firearm ownership and the avoidance of unnecessary conflict. Incorrect approaches analysis. One incorrect approach would be to immediately confront the individual whose firearm was observed. This is a regulatory and ethical failure because Arizona law does not grant a permit holder the authority to police the firearm possession of others in public. Such an action could be construed as harassment or an unlawful intervention, potentially leading to legal repercussions for the permit holder and escalating a situation unnecessarily. Another incorrect approach would be to report the observation to establishment management or law enforcement without any indication that the firearm is being brandished or used unlawfully. While reporting suspicious activity is generally encouraged, simply observing another person's lawfully carried concealed firearm in a place where carrying is permitted does not constitute suspicious activity under Arizona law. This approach could lead to an unwarranted investigation and inconvenience for the other individual, and it demonstrates a misunderstanding of the scope of a permit holder's responsibilities. A further incorrect approach would be to draw one's own concealed weapon in response to observing another's firearm. This is a severe regulatory and ethical failure. Arizona law strictly governs the use of deadly force and the brandishing of firearms. Drawing a weapon in such a scenario without an immediate threat of harm constitutes unlawful exhibition of a firearm and could lead to criminal charges, including aggravated assault, and the revocation of the permit holder's CWP. Professional reasoning. Professionals should approach such situations with a calm and informed demeanor. The decision-making process should involve 1. Assessing the immediate environment for any actual threat or unlawful activity. 2. Recalling and applying knowledge of relevant Arizona revised statutes concerning firearm carry and use. 3. Prioritizing personal safety and de-escalation. And 4. Acting in a manner that is both legally compliant and ethically responsible, avoiding any actions that could be misinterpreted or lead to conflict. If there is no immediate threat, the most prudent course of action is to disengage and remove oneself from the situation. Question 20. Cost-benefit analysis shows that offering a bundled package of Arizona Concealed Weapons Permit, CWP training, and a discounted firearm purchase from the instructor's dealership could increase revenue. If the instructor also owns a firearms dealership, what is the most ethically sound and professionally responsible approach to managing this potential conflict of interest during CWP training in Arizona? Option A. Conduct CWP training as a distinct service, providing objective information on firearm selection criteria relevant to Arizona law and permit holder responsibilities, while clearly disclosing the instructor's dual role as a firearms dealer and offering trainees the option to purchase firearms from the dealership separately, with no obligation. Option B. Make the purchase of a firearm from the instructor's dealership a mandatory component of passing the CWP course, presenting it as an essential step for permit holders to ensure they have appropriate equipment. Option C. Offer a CWP Training Plus package where a significant discount on a firearm purchase from the dealership is contingent upon completing the CWP training with the instructor, implying that this is the most advantageous way to obtain both services. Option D. During the CWP training, exclusively recommend and demonstrate firearms that are currently in stock at the instructor's dealership, presenting them as the most suitable options for permit holders, without mentioning or comparing other makes or models. The correct answer is A. Conduct CWP training as a distinct service, providing objective information on firearm selection criteria relevant to Arizona law and permit holder responsibilities, while clearly disclosing the instructor's dual role as a firearms dealer and offering trainees the option to purchase firearms from the dealership separately, with no obligation. Explanation. This scenario presents a professional challenge for a licensed Arizona Concealed Weapons Permit, CWP, instructor who is also a firearms dealer. The core of the challenge lies in balancing the instructor's ethical and legal obligations to provide accurate and unbiased training with the potential financial incentive of selling firearms to trainees. The instructor must ensure that the training provided is solely focused on meeting the Arizona CWP requirements and does not unduly influence purchasing decisions. The best professional approach involves a clear separation of the training service from the sales service. This means that the CWP training itself should be conducted without any direct or implied pressure to purchase a firearm from the instructor's dealership. Any discussion of firearm selection should be general and educational, focusing on factors relevant to a permit, holder's needs and legal compliance, rather than promoting specific models or brands sold by the instructor. The instructor should clearly disclose their dual role and any potential conflict of interest to trainees upfront. This approach aligns with the ethical principles of transparency and avoiding undue influence, ensuring that trainees make informed decisions based on their own needs and research, not on a perceived obligation to the instructor. Arizona law and general ethical standards for instructors emphasize providing objective information, an approach where the instructor offers a package deal that includes CWP training and a discounted firearm purchase, with the discount contingent on completing the training with that instructor, is professionally problematic. This creates a direct financial incentive for the instructor to push sales, potentially compromising the objectivity of the training. Trainees might feel pressured to purchase a firearm they do not need or that is not the best fit for them, simply to receive the advertised discount. This blurs the line between education and sales, potentially violating ethical guidelines that require instructors to act in the best interest of their students. Another professionally unacceptable approach is to exclusively recommend firearms that are in stock at the instructor's dealership during the training session, without disclosing that these are the only options being presented. This limits the trainee's exposure to a wider range of suitable firearms and can be seen as a form of steering sales. While the instructor may genuinely believe these are good options, the lack of broader disclosure and comparison is a failure of transparency and can lead to suboptimal purchasing decisions for the trainee. Finally, an approach where the instructor makes the purchase of a firearm from their dealership a de facto requirement for passing the CWP course, even if not explicitly stated, is a severe ethical and potentially legal violation. This would be an abuse of the instructor's position and would undermine the integrity of the CWP certification process. The CWP training in Arizona focuses on legal knowledge and safe handling, not on the specific purchase of a firearm from a particular vendor. Professionals in this situation should adopt a decision-making framework that prioritizes transparency, objectivity, and the best interests of the trainee. This involves clearly delineating the roles of instructor and salesperson, disclosing any potential conflicts of interest, and providing unbiased information. When offering additional services or products, such as firearm sales, clear and separate pricing and terms should be presented, and trainees should be made aware that they have the freedom to purchase elsewhere.